Welcome to All Things Work. I'm your host, Ann Sparanco. Losing a job unexpectedly is something no one wants to either think about or even go through. If you've been there, you know it's an experience that can feel really overwhelming, confusing, deeply personal, leaving you unsure what to do next. Having a roadmap to guide you can really help provide clarity through this chaotic time when you kind of feel like there's no control in your life. So today we're focused on helping employees to experience involuntary termination. To answer the question, now what's next? Here to help with the roadmap is Jim Reidy, an employment attorney at Sheehan Phinney Bass Green, who recently spoke at a SHRM 25 conference about involuntary termination. Now, by the end of this episode, we'll all have a better sense of getting our footing after losing a job unexpectedly and also understanding some of our legal rights. We'll also share some HR focused questions that you, our audience, recently sent us on this topic. All right, welcome to All Things Work, Jim.
Thanks so much for having me, Ann.
It's great to have you. This is such an important topic. We know there are even some gray areas. And I think one of the big questions, like we said, is what's next? What should I do in this situation if I were to come across from it? So, Jim, let's talk about what happens following an involuntary termination, which simply means an employee is let go from their job rather than choosing to leave on their own. There's that big looming question, like we mentioned earlier. Now what? What do I do when I face this situation after receiving such bad news? What are the immediate next steps employees should really take in this moment, especially when they feel like they don't know what to do?
So I'm a management side lawyer, but that being said, meaning I represent the employers, but I've represented employees before. But as I represent employers, I want to give them a sense of this is what to expect when you've terminated an employee. And so I think it applies across the board. And so for that employee who's been terminated, first of all, I think as you said, a lot of information to digest right away. Now, some might expect it, some assume it's happening, but sometimes it's a complete surprise. No matter whether it's in the cards or it's a complete surprise, I think just about everyone lives up to their income level. So immediately the economic concerns. I've got bills to pay. What am I going to tell my significant other? What am I going to do next? Can I find another job? And all these things come crushing down. In addition to the emotional component and the component that is basically, it affects my self-esteem. All that stuff goes into that alchemy of, holy cow, what's next? So my advice would be, and this goes to the HR folks talking to and delivering the message, is keep it calm. Don't, as the employee receiving the message, don't overreact. Don't say something you're going to regret. Don't do something you're going to regret. And just take the information in, ask some questions like final pay, conversion of benefits, personal property return, and related issues, post-employment issues, and then let it digest before you do something next.
So I love that you brought up that emotional side because it really does impact someone so emotionally. You are wondering, what the heck? I don't know how to even tell my partner about this. I'm so scared because maybe I just bought a house and now how am I going to pay off, the mortgage? And I think this job market is so difficult. What do I do about getting a job as soon as possible? So there's a lot of panic. And I think we can all relate to that as that moment of panic. And, I really love the advice, you threw out on, taking a second, understanding what you need. So when it comes to what to expect from your employer, we know documentation, is very important. But do you have any other legal advice that is, essential for the employee to keep in mind, especially in the moment? We don't want to be in that seat being told, hey, you have to sign this paper acknowledging that you are now being terminated from your employer. Nobody wants to be there, but they should be prepared for that moment if it were to ever come.
Yeah. And I think that the answer there would be careful. If you're the employee receiving the information, listen carefully. And oftentimes when someone's being told you're being terminated, suddenly everything shuts down and their mind goes elsewhere. But listen to what's being said to you. And it might be the reason why you're being separated. It might be the effective date. It might be issues with regard to final pay and benefits. And perhaps, as you said, someone providing a copy of a separation agreement or something to sign. Always being careful about what you sign. And in most laws are going to say you've got a period of time to look at it. You can't be forced to sign something right away, generally speaking. So it's trying to listen, trying to process what you can at that point, but not being pressured into doing something that you don't fully understand.
And it could be easy to fall into that pressure when you feel so a little blindsided in that moment. So it's understandable. I do have just kind of a random question. Is it smart to ask for your employer for, maybe a document explaining the reason why, so that, for example, if you were let go due to budgetary reasons, it had nothing to do with your performance, and you want to make sure your next employer is aware of that, so you have a better chance of getting that job. Is that something that you can ask your employer to do?
You can ask all sorts of things as an employee, and you're a consumer at that point. You want to ask questions. Why me? You can certainly ask that, and depending upon the jurisdiction, some states require that you're given a reason. Others, you've heard the concept of at-will employment, which you don't have to give a reason. My recommendation to employers is give a reason, but stand by it. Make sure it's the right reason. But at that point, asking other questions like, can I have the opportunity to resign? Who's going to provide a reference? What are you going to do about my commissions, my bonuses, things of that nature? But that requires a fair amount of focus. Oftentimes, it's the shock and awe of termination that sets people back on their heels. And those thoughts usually come afterwards when you're able to digest it a bit more.
Yeah, I think a lot of us can understand that. So we talked a lot about what you should absolutely do in the moment to be prepared. But what about the things you should avoid doing? We know that there can be maybe small mistakes. Again, like you said, you're in this mindset, a little shock and awe. So what would you advise against doing in this moment and possibly the days following it?
So again, as a management side lawyer, I've seen a lot of those mistakes post separation. One would be acting out inappropriately by violence, by threats, overly emotional, walking through the workplace, screaming and yelling, downloading information that they shouldn't download. The person shouldn't download confidential company information, sending it to their personal computer and so on, stealing from the company and the like, going online, social media, going online and disparaging the company and things of that nature. Things will go downhill fast if that were the case. And again, that's just raw emotion. My recommendation is take a beat, take it easy, digest the information. It may not be fair. It may have come out of the blue, but digest the information first before you decide in a fairly unemotional state what to do next.
And so this conversation has felt pretty black and white here. So I would love to touch on the gray area a little bit. This is where it can get a little tricky. So in addition to any tangible company property like computer hardware, as you mentioned, an employee has to return, there's also intellectual property. Now, when we hear this, it can be a little vague, and it depends on the type of company you work for and all these other factors. So what would be defined as intellectual property potentially in just a regular case like this?
So you're right. It depends upon the nature of the workplace. It depends upon the person's job. But it really would be those things that the company has invested in, that the employer has a legitimate business interest in protecting. Its goodwill, its client lists, its customer lists, its marketing plans, its pricing structures, its formulas, its manufacturing process and the like, things that are not generally known to the public. And if they're disclosed, could have an economic impact upon the employer.
So we're going to get a little grayer here. Could a terminated employee accidentally mishandle intellectual property in trying to give it back? And if so, what are those consequences? It's a little confusing as to what could possibly come of this.
Yeah, a lot of employers will require employees to sign a confidentiality and non-disclosure agreement at the outset or have a policy in that regard. But even if they don't have that, again, accidentally, it's entirely possible. Maybe my cynical approach to that would be It might be in part that sort of mix of being vindictive or trying to protect your own interest as the employee who's leaving. Um, I think being very, very careful, knowing that the employer can take some very harsh steps to recover that information, and sort of the epilogue, if that person goes to a new employer, uh, possessing that information, either in written form, electronic form, or just something in their head that they can share with their new employer. The former employer can take some pretty harsh steps, which could interfere with that person's next job.
And I think a lot of employees are just, they just want to make sure that they don't want to make that mistake. I know you said it's really not that common, but it's like when you're going through the airport security and you're like, wait, do I accidentally somehow have a weapon on me, even though you've never touched a weapon in your life? It's kind of like that mindset. So it's always good to at least question, making sure everything you have, is, cleared out before you formally leave the company or organization.
Yeah, certainly. And what I recommend is the employer's counsel is being clear about what your expectations are for the return of company property, and then for the employee to follow those instructions specifically.
Yeah, it's really important to have clear communication in this on both sides. So thank you so much for that insight. We'd like to now jump into our audience Q&A focused on some more HR focused advice. So in a recent All Things Work newsletter, we asked our subscribers to submit their questions about involuntary termination. So to our audience tuning in today, be sure you're subscribed. You'll find the sign up link in our episode description. Your response to our question of the week could actually be featured in an upcoming episode. So that would be very exciting. All right, so let's jump into this Q&A. We have Loretta from Ohio. She asked, who should handle the termination? As in, who should be delivering the message to the employee? Is it HR, their direct manager, or somebody else?
My recommendation would be HR and the direct manager. So two people present, and it should be the direct manager because that's the person who perhaps evaluated the employee, and HR to go through the other housekeeping items. You remember the movie Up in the Air with George Clooney a few years ago, and it was the disembodiment of the termination session. It was you're being terminated by someone on a computer screen who you have no connection to, and that adds insult to injury.
That's a good point to make. Yeah. All right. So my fellow Anne, also from Ohio. Hi, Anne. Thanks for submitting a question. She asks, what are some things you can do to humanize the termination process? Oh, I really like this question.
Yeah, I think having a conversation, but even before that, giving the person hopefully some degree of some sense of what the job requires, where they're falling short, giving them an opportunity to improve. And then at that point, there's a sense of fairness when we've tried, it's not working out, it's not a good fit. And then having that conversation, never wanting to argue with the employee, never want to disparage the employee. Obviously, it depends upon the circumstances, tailored to the conversation, but really being decent and fair, recognizing that this is going to be a significant life event for this person.
Yeah, it's really good to keep that in mind. And that's why we're talking about it today. It's also to help people, remind themselves, hey, if I'm on the delivering of the message kind of side, it's good to remember this isn't easy for anybody, especially the person receiving the news. So
I'm going to give another quick media reference and goes back to the Seinfeld days. And
I love Seinfeld.
yes, and it was, never be George in a termination session, which is, it's not you, it's me. No, if it's the employee, just be kind, be decent, but be direct. It's you. It's not the organization. Don't say things like, well, we're going through cutbacks, or we're reducing staff, or we're laying off, and if that's not true. If it's the person's performance or conduct, then that's what you say.
Don't be a George Costanza. All right, awesome. We have another question. Melina from Cypress, California. She asked a really great question here. Would you terminate with immediate effect in order to safeguard the employer against potential retaliatory acts from the employee? It's a great question.
It's a great question. Let me answer it this way. I think the answer is it depends. But generally speaking, I think a separation right away or within that week makes perfect sense. Why? The tether between the employer and employee has been severed. Think about the situation. I like to compare it to a divorce. I'm divorcing you, but you can stay in the house for the next 3 months. And I can see others and you can see others, but this is the way it's going to be. never really works out all that well. And so if you have that transition period, that it's going to be very difficult. And most times when that happens, the employer then says, this is not working out. And we're going to accelerate the departure. So I think to the extent possible, as long as it makes sense, have an immediate termination. If there are those few examples when you can have an amicable separation, either a retirement or a period of time for transition, maybe, but those have to be handled with care.
I love that analogy you made. It really it paints a clear picture for people. And immediately I don't know if you saw my eyebrows raise. I was like, oh, no, don't want them in the same house if they're not going to be happy together. So now from Melina to Melanie from Florida, who asked, as an attorney, what do you advise your clients say during a termination in a state with a right to work law? Ooh, we're getting down to the nitty gritty details. Okay. She also asked, should they always give a reason specifying lack of performance or attendance, or should they just try to keep it general? You touched on this a little bit, but let's dig a little deeper.
Yeah. So what should the employer say? I think the employer should be direct and say, your employment is being terminated for the following reasons. Now, do you need to give a reason? At-will employees, the employer can let them go at any time for any reason or for no reason, with advance notice or not. Right to work states are basically that you have a right to work whether or not you're a member of a union or not. But my advice is, with regard to the message, plan in advance, know what you're going to say, know who is going to be present. Obviously, you've prepared in advance. You've got the evaluations, the documentation that if it's ever tested, but then being clear and being, as we said just a minute ago, being decent and direct, being simple, focus on not their personal problems, not things outside the workplace. Generally, it's in the workplace. Here's the job. This is where you've fallen short or why we're making this change. And then let's talk about what's next, whether it's final pay, separation pay, and other things that might follow the separation.
Yeah, that's a good way. Like you said, be straightforward, communicate intellectually here, but you're not required technically. So that's good to keep in mind. Now, I'd love to get your insights for how HR should respond in complex situations around terminating an employee, as well as how they can protect their organization from certain risks. We'll dive right into it. How should HR handle terminations involving protected classes like age, disability, race, and more to avoid EEOC claims? This is a tricky one.
A great question, and it's something I deal with every day. And the answer is being prepared, recognizing whether or not the employee is a part of a protected class. And with that, is that the reason why the person is being separated? Hopefully not. Hopefully it's not because of gender, race, religion, age, disability, and so on. Hopefully it's because of business needs, person's performance, and the like. So certainly being aware, and then knowing that there is a higher risk potentially of disparate treatment with the individual, making certain in the case of age is not the reason. In the case of other protected classes, when you deal with what's called mixed motive, you want to make certain that gender, maternity, disability, religion, all those things, and perhaps even more than one, are not a part of the calculus. And that you've got documentation showing that this is benign and has nothing to do with that person's protected characteristics.
It's good to keep in mind. Thank you. And so, what are the HR risks and best practices for terminating an employee on leave, whether it's FMLA or ADA? We know that this can get a little tricky. It's not something an employer really wants to do, but the situation might call for it, depending on the reason. So, what are those risks, and what can HR really do in this situation?
First of all, being aware, if the person's on FMLA, why is that person selected for the RIF or the termination? And the same is true with someone with an ADA disability and accommodation. Why is that person selected for the separation? Can it happen? Can someone be separated who's on FMLA? The law says yes, it can. If you would have terminated that person otherwise, if they were not on FMLA. If the person with the ADA disability and or perhaps an accommodation, would you have terminated that person in any case, regardless of their physical or mental disability or their accommodation? Yes, but proceed with caution because the risks are high. And the person say, well, clearly it must be I was selected because of and not for any other reason. And that goes back to that termination discussion. Make sure the reason you give is the real reason.
Exactly. And this is where communicating clearly is even more vital because you're having someone then who's going to come to you and say, okay, but what happens with the rest of my leave? What do I do? What does this mean for me? Where's the documentation? So I think being prepared to answer those questions is vital as well, right?
Absolutely. And I think then that's a big one because during FMLA, someone's benefits are continued. Either they're contributing to the benefit premium or the employer is covering it. Well, the minute termination happens and FMLA ends, that person then has to pay for their benefits. Yeah, that is something that next to wages, benefit coverage is perhaps the most important thing to that individual. And the same is true with regard to disability and accommodations, especially if that person's now worried about how am I going to find another job?
Exactly. There's a lot more swirling in their heads. Let's do that. So, what should HR also make sure is included, let's say, in a severance agreement, a severance package is what people might call it, to protect both the employer and the employee? Because right now, this is a situation where HR is really trying to make sure both are covered here.
Yeah. So I think one, having legal counsel assist. And this is not a commercial for my services. It's just that having competent legal counsel that's dealt with matters like this before handling it, not using ChatGPT or AI of any sort, not finding something on the internet, having an agreement that is vetted by a lawyer and tailored to the circumstances. So the answer is it depends upon the employee. Does a person have a contract? If the person doesn't have a contract, do you have any related agreements like non-disclosure agreements and non-solicitation? Should those be included? And then it should be plain English. It should be, or whatever the person's primary language is, it should be very clear. This is what's happening with your final wages. This is how you return company property. This is how references are handled and how unemployment will be handled. This is the general release, and this is what the post-employment obligations are. It should be very straightforward in plain English or whatever the dominant language is that the person can understand and hopefully abide by the agreement.
Gotcha. Makes sense. And there's a lot of risk of legal backlash or even public scrutiny. You touched on retaliation earlier in part one of our episode. And I thought it was really interesting that you brought it up so early because it is something on the minds of the employer is, what happens if this employee is upset, whether they go on social media and badmouth the brand or organization, or up to even more violent or aggressive acts. So when it comes to that, what advice do you have for organizations to respond to even lawsuits as well? Like, I would love to jump into the lawsuits realm here. What advice do you have for organizations to respond to lawsuits or negative publicity following terminations?
A couple of things. I think one is the logistics in connection with the separation. My recommendation is always do it in a room where you're not going to be interrupted, that you can have a direct and civil conversation with the employee. But also, because we live in the world of worst case scenarios, have it in a situation where if something bad, catastrophic were to happen, there's a way to get out of that room. That sounds awful, but unfortunately, that's a reality. Let's deal with the after effects. How do you deal with what happens after the separation? I think reminding the employee at the time of separation that these are your obligations. If you're presented with a separation agreement, this is how much time you've got to consider it, and so on. And then I recommend for employers to monitor the activity afterwards, whether on social media or discussions or checking email, because hopefully during the termination session, the person's access has been cut off. But if not, monitoring afterwards to see if there was something that was done that was sort of injurious to the company.
That's good to keep in mind. Thank you so much for walking us through these scenarios. We know that it's not always black and white and it can be very emotionally driven. So the awareness and the effective communication strategies hopefully will take our audience pretty far here today and remind them that, both sides are dealing with this in equal amounts. So thank you so much for walking us through this, Jim. We appreciate your insights today.
My pleasure.
Thanks for joining us, and we'll see you next week. If you enjoyed our conversation today, be sure to subscribe wherever you enjoy your podcast so you never miss a new episode. Also, did you know All Things Work is more than a podcast? That's right, we're also a weekly newsletter that includes in-depth articles and the latest research from SHRM to keep you in the know. Just head to shrm.org/allthingswork to sign up. Plus, follow SHRM on social media to view the latest clips and join the conversation on game-changing topics that are redefining the world of work.
SHRM.